Okay, next essay we're going to do is from 2014, February. It's question 1, professional responsibility. And this one has to do with the area that's not heavily tested, but has to do with the special responsibilities of a prosecutor. Let's look at the call of the question. What ethical violations has Patty committed? Well, who's Patty? It's not L for lawyer, A for attorney.
Turns out to be P for prosecutor. So he has the special responsibilities of a prosecutor.
Okay, answer according to ABA and California authorities. 3 months ago, a week ago, 4 days ago, 3 days ago, yesterday, this morning. Why did I just do that? If you notice that each paragraph starts with a certain point in the timeline. That leads me to believe, okay, something's really important here about the timing. You'll notice in contracts essays and wills essays, they do this all the community property essays, they do it all the time. You must pay close attention to days on months, dates on the bar exam. It's super important. And here ends up what happening is a lot of the issues revolve around the timing of when things were disclosed, when charges were filed, when statements were made, whatever the case is, when witnesses were identified, when evidence was discovered. So that turns out to be important. Don't ignore things on the page. No, 3 months ago, comma, a week ago, comma, 4 days ago, comma. That's the examiner's way of trying to draw attention to it. By the way, if you have not read this essay, if you have not looked at the fact pattern yet, before you go continue on with this video, push pause, read the fact pattern 3, 4, 5 times. And I'm not kidding you. Make sure you understand the facts really well so that when we do, and you can even read the model answer before you get into this discussion. Because I want to be able to explain things to you where we're on the same level and you understand exactly what it is that I'm saying. But we always do essays the exact same way. First thing we do, go to the call of the question and take it to the top, slowly and carefully. On the bar exam, I will read the fact pattern 3 or 4, possibly even 5 times. Yes, I will. Every single time. Because how am I supposed to know what to write unless I'm thoroughly familiar with what's going on? So I don't read it once quickly. I don't read it once okay, and then the second time I skim it. It doesn't work like that. You read it, and if you don't think you have time, you are way mistaken. You actually save time by slowing down and doing things the right way. All right. 3 months ago, Dave was arrested for burglary of a shoe store after a forensic investigation by the police department identified him as the burglar. Probably have DNA, hair was found, whatever the case, his shoe print, fingerprints. Patty, a prosecutor, brought burglary charges against him. Okay, so a prosecutor generally has the responsibility to bring charges supported by probable cause. So right now it seems like, okay, there's probable cause. And again, the exact order that you put things in is not that important. All right, the examiners aren't gonna be like, well, you should have put that one second and not first. No, it doesn't matter. So right now, you could put charge supported by probable cause first, but there's not an issue to probable cause yet. It turns out to be later afterwards. So we'll get into that, but if you just want to make a note, that's fine. So that's the point, it's a probable cause requirement. And you could say, I mean, you could bring it up now and you could say, okay, Patty had probable cause to begin with. All right. A week ago, Patty saw a press release. Now, a press release is going to be widely disseminated to the public. That the police chief and the police chief works under or works with the prosecutor. So Patty has a duty to prevent others from making extrajudicial statements, that means out-of-court statements, that the prosecutor herself is not allowed to make. So Patty has a responsibility to tell the police chief, whoa, before you issue this press release, it can't violate the duty of trial, the extrajudicial statements, and that means like trying cases in the press. We'll get to that in a second. Patty saw a press release that the police chief was planning to issue to the media, which means it's going to likely taint the jury pool. It stated that Dave was a transient and had been arrested for burglary by an inspector who is known for his ability to apprehend guilty criminals. Well, one of the statements you can make. So now we have what's called trial publicity. And what that rule says is that a lawyer cannot make any out-of-court statements that are going to be widely disseminated that might have a material prejudicial effect on the case, on the trial. Criminal trials are most likely to be sensitive to this type of information because it's going to taint the jury pool. So we're already calling this guy guilty, and he hasn't even had due process yet. So you see why, and now you see why the police chief shouldn't do this? But you're saying, well, the police chief's not a lawyer. Correct. So the police chief does not come under these professional responsibility rules. That's why it's the duty of the prosecutor to make sure that the police chief doesn't make this statement. So while Patty can't force him not to make the statement, she should exercise reasonable care to prevent him from making this statement, okay? So that's what trial publicity is in this regard. 4 days ago, Patty received a report from a federal agency stating that the police department's forensic identification identifying Dave as the burglar was unreliable. Now, we have no probable cause. At least she didn't 4 days before. So Patty finds out that, wait a second, I don't have my forensic reports. It says Dave was arrested after a forensic investigation identified him as the burglar. Now the DNA comes back and says, wait a second, we got it mixed up. It's actually not him. So she has no probable cause. And she has a duty, and a continuing duty, to not prosecute a charge that's not supported by probable cause. So she actually has to dismiss the case. Furthermore, one of the things Patty doesn't do is she finds out now child publicity was like there, duty to control others. Those under you. Okay, so now Patty knows that we have exculpatory evidence that helps the defense. So this is going to show that the defendant's actually not guilty. So she has a duty to disclose exculpatory evidence automatically. By not doing so, she violates due process and is called a Brady violation because of the case, United States Supreme Court case, Brady versus Maryland. Okay. 3 days ago, Patty announced she was ready for trial at a pretrial conference. She just lied to the judge. She's not ready for trial. She has no evidence to go to trial. She has no forensic reports, no witnesses, no videotape, nothing whatsoever to show that Dave, the defendant, was actually involved in the burglary. So by telling the court, I'm ready for trial, duty of candor to the court. How about lying to the judge? That's exactly what's going on here. Yesterday, Patty learned that 2 eyewitnesses had identified Dave as the burglar. Oh, well now we have 2 eyewitnesses. So now we're ready for trial, but you weren't then when you told the court you were. You see how it's all about the timing issue that we really discussed earlier? And now she may have probable cause. Although 2 eyewitnesses probably would amount to probable cause, enough to go to trial and let the jury determine the witness's credibility. But when she said it 4 days ago, she didn't, but yesterday she did. So in that gap of time, those 3 days right there, she had no probable cause, was not ready for trial, did not disclose the evidence, and these are all violations and they're special responsibilities of the prosecutor that she breached. Yesterday, Patty learned the 2 eyewitnesses had identified Dave as the burglar. Because she did not intend to use the evidence from the forensic investigation, because it shows that Dave's not the burglar, she did not disclose the federal agency report to Dave's attorney. So if you miss the disclosure of exculpatory evidence, the examiners go out of their way to make sure that you caught it, so you can't miss the issue. So the prosecutor in a criminal case must make timely disclosure of all evidence that is favorable to defense, whether it tends to negate the guilt of the accused or mitigates the offense. Think about it. Let's say Patty's not going to use the forensic evidence. So she's not going to use the DNA because the DNA came back negative. Don't you think that's going to be super helpful to the defense? So you have 2 eyewitnesses that say, yeah, Dave did it. And we say, yeah, but you have DNA that says it wasn't him. And eyewitnesses, what's more reliable, an eyewitness or DNA? Come on now. I mean, Bernie Madoff is more reliable than an eyewitness, and that is goddamn truth. So eyewitnesses are very unreliable, highly unreliable, and it's actually something like 67% of eyewitness testimony is inaccurate. And it's not intentional, it's just the way the mind plays tricks on people. So we have two witnesses, we have all this exculpatory evidence saying that he actually wasn't at the scene. Could you imagine two people saying that I raped a girl, but the semen comes back and it's not mine? Don't you think that would be helpful to my case? So that's exactly what's going on here. And she has to tell the defense that, because that is really important exculpatory evidence and has to be automatically and timely disclosed. So this is a violation of due process. This is a mess what Patty's gotten herself into. Unfortunately, this happens every single day at the DA's office. This morning, Patty called the judge. Why are you calling the judge? You don't just call the judge unless the other side's there. Who will be presiding over Dave's trial to reassure him that there is ample non-forensic evidence to convict Dave. Why is Patty calling the judge? It's a one-sided conversation that's likely to influence the judge's decision, the judge's introduction into evidence and rulemaking and any kind of other decision that the judge may be put on during this trial. So she can't call him by herself. She has to have other counsel there. So this is
No ex parte communications. And if you notice something, examiners kind of do lay it out well.
like the last paragraph goes to the ex parte communications. The yesterday paragraph goes to the probable cause requirement and the duty to disclose exculpatory evidence. The 3 days ago paragraph deals with false statements to the court. The 4 days ago has to do with probable cause. So actually, there's the probable cause. And the week ago comes the trial publicity. So you have 5 different paragraphs and 5 different legal issues. This essay was only 5 legal issues, and it was 5 paragraphs. So here, you want your organization? It just goes right in order. Here's the 5 issues. That's simple. So now when you break it down, it becomes a lot easier to look at and a lot easier to organize and put together, and it's impossible to miss things. You know, every fact in each paragraph is going to go to that precise issue. Now, does this happen all the time? No, absolutely not. Does it happen a majority of the time? Yes, it does. So don't ignore this. This is very important. It happens all the time. It happens a lot of the time where the examiners will put, they'll cluster, one issue in this paragraph, one issue in this paragraph, or this will go to this paragraph will go to this call. This next paragraph will only go to that call, so on and so forth. So pay attention to that. I mean, this exam's a lot easier than most of you guys make it out to be. So treat it with the respect it deserves, but don't be intimidated by it. It's actually a pretty good exam. Okay, so there we go. All right, so now we have, again, the special responsibilities of prosecutor, the duty to control others and make sure that those under you are not making any out-of-court statements that are likely to prejudice the trial. Again, criminal trials are very sensitive to that, and Patty should probably do everything she can to exercise reasonable care to prevent the chief from releasing this press statement, because it shows that the defendant is guilty, and it really is going to prejudice the case because a lot of the potential jurors might be tainted. Then we have the probable cause requirement. She had no probable cause 4 days before because the only evidence she had came out to be that the defendant was actually innocent. So there was no probable cause in that regard. Duty of candor to the court. She was not ready for trial when she told the court she was ready for trial because, again, she had no evidence to go forward with trial. Can't lie to the judge. She also failed to disclose the forensic evidence to the defense, and you must disclose all exculpatory evidence automatically, and you must do so promptly. And finally, by calling the judge and saying, I have ample other evidence, you're trying to influence the judge, and that's a prohibited ex parte communication. This was a good essay. It really dealt with some of the least heavily tested issues in PR. That's why I think it's good to hit on, just in case you don't get caught off guard during the exam. And there you go. That's a wrap for 2014 February, question 1.